Good morning to all of you. Welcome to Legal Matters by Sai Babu Sankara. Friends, yesterday I have made the video regarding freebies in which we have discussed the Balaji case. He is S. Subramaniam Balaji versus State of Tamil Nadu 2000 judgment. It has to be revisited. Of course, yesterday, day before yesterday, Honorable CJI, he stated that an expert committee or parliament committee expert committee will be established to look into the freebies issue. Of course, since he retired, so things will take place in a normal way. Now, whenever you hear of Balaji judgment, not only that Balaji, there are three Balajis. Together, we are going to discuss another Balaji. This Balaji, please remember, this case is called as Bar Council of India versus A K Balaji. He is also Tamilian basically. So Bar Council of India versus A K Balaji 2018. So it was a civil appeal number 7815 by 2015. Sorry. Decided on 13/3/2018. So please remember, basically in the 6th semester we are going to discuss this case law because it's a landmark judgment regarding the foreign advocates practice. Actually, during the installation of the so-called starting of international commercial arbitration, we know that arbitration will take place between Indian companies and multinational companies also. Even so many multinational companies, they have started functioning from India. In India also, if some disputes are there, you have to go for arbitration. So they have to bring their advocates. Foreign advocates are coming. Even the government of India was interested in allowing the legal profession to the foreigners also, but Bar Council of India vehemently objected. Right? Actually, this A K Balaji filed a case before the the High Court of Madras. Of course, they also agreed with him, but asked the BCI to take into action. Ultimately, BCI has taken action. Now the matter air is cleared that how this happened. Now we go to the facts of the case. Please remember. Before that, let us know the provisions of the Advocates Act. You all know that according to the Advocates Act, simply I will tell you, Section 24, Section 29 and also Section 17 is also there. Because to practice law, one should be a citizen of India, first point, citizen of India. Number two, he must pass or he must get a degree, law degree from a recognized university. No doubt, he can get a law degree which is actually recognized by the Bar Council of India. And even though he is belonging to other country, he can practice in India after getting enrollment. And if the degree is recognized by the both states, suppose if UK allows your BL in UK, then the barrister can be allowed in India, right? But please remember, this is what is called reciprocation. Otherwise, the foreign advocates are not allowed to practice in Indian courts. But because number of multinational companies, the BPO, Bridges Process Outsourcing companies, they are providing wide range of services like word processing, then secretarial support, then transcription services, travel desk support, and so many sevas or services they are doing. Right? Suppose if any dispute arises, what happens? So even though they are doing all these services, if any advocate wants to represent them, he cannot, because Advocates Act 1961 clearly says that the person should be a citizen of India. Right? So now so many foreigners are coming. So whether foreign law firms are permitted to practice in the law in India or not. Right? So I have discussed the international commercial arbitration as per our Arbitration Conciliation Act 1996. Yes. So here, as per the Act, for Arbitration Act, foreign lawyers cannot be debarred to come to India because they know their provisions. They are different provisions. So therefore, they can be allowed. When the government also has allowed them, therefore they are coming. But when Balaji filed the case, High Court of Madras clearly stated that yes, unless you are registered as an advocate in India, you cannot be allowed to practice. And when these law firms like Clyde and Co, so many companies are actually A K Balaji cited 40 persons. Out of them, 3 or 4 are government officials, others are foreign firms. So to establish a firm, you have to take permission from the RBI. Under section 29 of the Foreign Exchange Act, Foreign Exchange Regulation Act, RBI is directed not to grant any permission to a foreign law firm till the air is cleared. Now, ultimately, the Honorable Supreme Court of India clearly stated that the Bar Council of India has to take a decision because the apex body, it is the apex body as far as the regularization of the advocates are concerned. Number 2, at the same time, actually, when the matter was brought before the notice, the Union of India, they stated that they wanted to bring an amendment to section 29 of the Advocates Act to allow the foreign advocates. But due to the resentment by the Indian advocates or the Bar Council of India, I think after 6 or 7 months, they changed their attitude. Now, the law says that yes, foreign law firms can fly in and fly out, but they should not set up their offices. Practically, okay, since the Supreme Court said we should not comment, but practically they will come. And what happens is they will advise our Indian advocates who have to represent in the court. Other things, everything, documentation, litigious practice, non-litigious practice, everything will be done by the foreign advocates. The only thing is our advocates will represent. At least otherwise, at least we will be happy. Otherwise, what happens if that man comes and starts speaking in bombarded language, then definitely it will be difficult for us also. Even it will be difficult for our survival. No doubt, if you go to the international arena, if your things are, if your thoughts are wide, yes, no doubt, we have to agree. But at the same time, as advocates, as Indian advocates, we should not support. So anyway, this same thing is done by the Bar Council of India, Union of India, the Government of India also agreed. Ultimately, the present position is fly in and fly out. That means the advocates from the foreign countries, they can fly into India, they can work for some time and immediately they have to get away. But they should not start any office in India. This is the settled position in A K Balaji, Bar Council of India versus A K Balaji 2018 case. So tomorrow we'll discuss another Balaji case, that is a reservation case. For this time, I am stopping here. Thank you very much.